An owner or business leasing a property has a responsibility to maintain the property in a safe manner. And what that means is they need to do inspections for dangerous conditions. That condition could be an uneven rise in the surface. It could be an air conditioner or refrigerator that's leaking. It could be that another customer that was on their property has knocked some things over and they've been out there long enough that they should have been cleaned up and a warning should have been placed out for the other customers. Slip and fall cases many times involve very serious injuries because, as you can imagine, if you trip on an uneven surface, you very well may fall forward, break your wrists, break your knee, or wrench your back or neck. Likewise, if the ground comes out from under you because there was a slick surface, you very well may fall backwards, land right on your tailbone, causing a massive shock and injury to your lower spine, or even all the way up through your upper spine if you fall back hard enough to hit your head. Slip and falls have a stigma of being hard cases. And the reason for that is in Texas, you've got to show the condition that caused someone to get hurt existed long enough for the store owner or property owner to discover and either warn or repair that condition. But that shouldn't scare people away from going after these claims. First of all, many uneven surfaces existed for plenty long for the store owner to figure it out. And they can be really good cases if you're not the first person that fell, because the store owner, property owner, should have known of the problem because somebody else actually got hurt. Even if your case involves a substance that was on the ground and you've got to prove how long it's there, many times we can do that. One of the first things we'll look at to prove how long a substance was on the ground, for example, in a grocery store, is the surveillance video. We get asked a lot, is it important to act fast when you've been injured as a result of a defect on somebody's property? And the short answer is absolutely yes. First of all, the property owner may go out and repair the defect, and without having a picture of it or some evidence of what the actual defect is, sometimes it's very hard to explain to people what the problem was or even prove there was a problem. Second, many times there's a video. And if there is a video, we want to act fast to either obtain a court order or get some sort of agreement that that video is not going to be destroyed and it's going to be maintained as evidence in your case. In a slip and fall, premise liability type case, the goal of the company or the insurance company is to minimize what they pay you. We see it over and over and over. First, they'll say, you must not be that hurt from what happened. You have pre-existing problems. Then they'll say, well, even if you were hurt, you should have seen the defect. You shouldn't have tripped. But we all know when people walk, they're looking out ahead. They're not watching their feet all the time, or they would trip on everything. So when there's a dangerous surface or an uneven surface or a slippery surface, it needs to be repaired or people are going to get hurt. In a premise liability case, you have personal injury damages available, which would include your medical bills in the past and future, your lost wages in the past and the future. That would also include if you have a loss of your ability to earn as much money going into the future. Compensation for any scarring you have, maybe as a result of a surgery, and also damages for your incapacity or inability to do certain things, and for your mental anguish, pain, and suffering, which is essentially the aggravation and the pain you went through as a result of being injured. In a premise liability case, we're going to have a number of potential defendants we're going to want to look to for compensation. First of all, whoever owned the property is going to have some responsibility to maintain it, but they may have given that responsibility to someone else. For example, they may have leased the property to a grocery store who then becomes primarily responsible to maintain the property, although the property owner may still be on the hook for part of your compensation. There may also be third parties, such as a cleaning service or construction service, that were involved in creating the dangerous condition. We'd want to potentially look to those third parties for compensation as well. Our firm was founded in 1964. We've been handling personal injury matters, including slip and fall matters, as long as we've existed. We're familiar with the issues, first and foremost preserving the evidence, gathering evidence of the defects so we can prove what it is that caused you to get hurt, and then making sure you get adequate medical care, and we build a proper damage model so you can get full and adequate compensation for your injury. Our current and past clients would say that we care about them, that we've worked hard on their case, no stone unturned. But really, I would urge people to go look at our reviews and see what our clients say, because they really speak for themselves. And on our website, we also have some testimonials if you want to watch a video and hear from someone in person. At Schechter, Schaefer & Harris, client communication is our #1 metric. In fact, we have a policy that every client will be spoken to every month. And at the beginning of a case, I'll tell you, we're probably speaking to you every day. We make sure that the attorneys and the case managers are calling the clients back. The attorneys and case managers are also provided a list every single week of clients they haven't spoken to in the last 3 weeks. So it's crucial that we talk to the clients to make sure their medical care stays on track, to make sure that their case development is moving forward, and most importantly, the clients want to hear from us. So we want to be talking to them and keeping them informed what's going on with their case so they're comfortable with the process. Here at Schechter, Schaefer & Harris, we're a medium-sized firm, and that has advantages. If we were really, really large, you would have all sorts of red tape and all sorts of levels of people you probably had to deal with to get your case resolved. On the other hand, if we were a sole practitioner with 1 or 2 legal assistants, you'd probably have an office of people who are overwhelmed and can't get to everyone and service the clients properly. I would call us a medium-sized firm. We're in the middle. And the way we divide things up is we assign a lawyer and a case manager and a paralegal to each of the cases, so every single case is getting adequate attention. What makes us different than other firms is we're real trial lawyers that are really going to handle your case the way a lawyer who might end up in court on your case would. Now, that's not to say every case is going to end up in court, because the vast majority of cases, especially if they're prepared properly, do settle. But it is important to have lawyers with a track record, and lawyers that actually try cases, and lawyers that are known to the insurance companies and the defense as willing to go to trial on your case to get the top value. People want to know what they can expect during their initial consultation for a premise liability case. We get asked that a lot. And one of the first things we're going to want to know is, do you have a picture of what was the premise defect, what caused you to get hurt? Because the question's going to be whether or not that condition was unreasonably dangerous. And without actually seeing the condition, sometimes it's very hard to determine if it's an unreasonably dangerous condition in our estimation.